Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Acting Leader of Government Business.
My apologies, Madam President. Madam President, I have the honor to lay on the table the following papers listed on the order paper in the name of the Minister of National Security. The response of the Trinidad and Tobago Police Service to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents. I thank you.
Questions?
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Energy and Energy Industries. In view of the temporary shutdown of the nutrient plant, what measures are being taken by the government to address the growing dislocation of workers at the Point Lisa's estate?
Minister of National Security.
Thank you very much, Madam President. Madam President, what we're seeing here in our energy industry is in fact a phenomenon that is taking place globally, because these commodity markets are being affected globally. The demand in the Asian markets, in the European markets for the commodity products that come out of Point Lisa's, including oil and including gas, has been completely wiped out. There is no more demand, so therefore the supply is affected. Another correction that needs to be made, Madam President, is there has been no shutdown of the Nutrien plant. What Nutrien have done is they've taken a decision to put a plant in idle. 1 out of 5 of their plants will be put in an idle mode for the next 90 days. They are not letting go any of their workers during this 90-day period. With respect to a growing dislocation of workers at the Point Lisa's estate, there is no such growing dislocation. As I said, the global commodity market based on petrochemicals is being affected. This is something that the government has absolutely no control over. It is part of the outcome of the COVID pandemic that is taking place. We will continue to monitor it. Fortunately, this administration's relationship with all of the shareholders of all of these plants at Point Lisa's is a good one, and they continue to be in constant conversation with us, doing the best that we can, working together to ensure that there is no dislocation of workers. There will be some fallout, but we are doing all that we can to minimize that, working along with the shareholders of these plants.
Senator Mark.
Minister, aware from newspapers report that some 40 workers on contract with this said company will have their services terminated. Is the minister aware of that, or is he confirming that those contract workers will not be terminated by the said plant?
Minister.
First thing I'd like to say, Madam President, certainly all that is read in the newspapers cannot, unfortunately, be taken as 100% accurate. If there are 40 contract workers that are going to be affected, as I said, the plant is being put in an idle format for 90 days. We continue to monitor. There's a lot happening globally. Nutrien have said that they have absolutely no intention to shut down the plant. So at the 90-day period, let's see what happens. As we've gone through the whole stay-at-home phase, there have been persons who have been affected. This is unfortunate, but it is one of the effects and measures of handling COVID-19.
Senator Mark.
President, is the minister aware that this would represent the 6th plant since 2016 at the Point Lisa's estate that have gone into an idle state or have been closed down? And whether the minister will want to tell this Parliament.
Senator Mark, one question.
Can I ask the minister to advise the Parliament in light of this development, to what extent the erratic increases in gas prices by the NGC based on negotiations conducted by the government of this country, headed by the Prime Minister? Could the minister indicate whether that situation of higher gas prices have had a negative impact on these particular industries located at Port Lisa?
Senator Mark, that question does not arise. Next question, Senator Hussain.
Good morning, Madam President. Thank you very much. To the Minister of Agriculture, Land and Fisheries, in light of the closure of one ammonia plant by Nutrien Limited, can the Minister indicate what steps, if any, will be taken to address the shortage of ammonia products to farmers and distributors?
Minister of National Security.
Thank you very much, Madam President. Madam President, it is quite apparent that unfortunately there's a lot of misinformation taking place. We see one of the members for the opposition talking about shutdown, another one now talking about closure. There has been no closure of any Nutrien plant. As I just said, it's been put 1 out of 5 of their plants at Point Lisa has been put into an idle mode for the next 90 days. 4 of their plants produce ammonia. 1 of their plants produces urea. The plant that has been put into an idle mode is an ammonia plant. Absolutely none of Nutrien's ammonia product is sold on the local market, so there will be no effect whatsoever, negative, positive, or otherwise, to our local agricultural workers. The urea plant that continues to run produces and supplies urea to our local agricultural market, and it will continue to do so unimpeded.
Senator Hussain.
Thank you very much, Madam President. Madam President, is the Minister aware that there has been a shortage of urea products for over 2 weeks now, and there are complaints made by farmers and distributors?
Minister.
Madam President, first of all, the whole direction of Senator Hussain's question was to address the shortage of ammonia. And for education purposes, ammonia is a different product to urea. Secondly, as far as we are aware, and I spoke to Nutrien before I left, there has been absolutely no effect, negative or otherwise, with respect to their continued supply of urea to the local market. So what I'm hearing is news, and as I said before, there's a lot of misinformation. Perhaps that misinformation was fed to Senator Hussain.
Senator Hussain.
Hush.
Next.
Madam President, is the Minister confirming that the temporary or the idle, the one ammonia plant being idle does not directly interfere with the supply of urea to farmers and distributors in Trinidad and Tobago?
Senator Hussain, I won't allow that question. Next question, Senator Hussain.
The Minister of Health, having regard to the availability of suitable state-owned step-down facilities to house COVID-19 patients, can the Minister explain why the state continues to rent the Brooklyn Settlement Sangre Grande facility? Leader
of Government Business.
Madam President, I thank the Senator for the opportunity to respond to this question. Madam President, you may recall that from the outset of the government's COVID response, the state health facilities were used and private facilities were used in the first instance for quarantine purposes, and the Balandra facility is one, and thereafter facilities were identified for what we call step-down purposes. My recollection is that the Brooklyn Settlement facility was one of the first step-down facilities. At that time, without being able to predict the length of the COVID and the impact on our country, the Ministry of Health engaged that facility for a period of 3 months. As it turns out, the last patient was discharged from that facility last Sunday, and thereafter there was need for a 2-week period for the decontamination of the facility. Madam President, out of an abundance of caution and recognizing that the Ministry engaged the use of this facility for 3 months, the facility will continue to be retained by the Ministry just in case it is required, and we hope it is not required, and if it is required beyond the 3-month period, the Ministry of Health will do what is necessary to secure and safeguard, as it has done very successfully, the health, wellness, lives, and interests of the citizens of this country. Thank you very much.
Very much, Madam President. Madam President, can the Minister confirm whether or not this facility is owned by someone who is very closely linked to the People's National Movement?
Senator Hussain, I won't allow that question. Next question.
And Madam President, is the Minister comfortable with the fact that there are several state-owned step-down facilities? What is the proper justification for the government continuing to rent this particular facility, which is privately owned, costing the taxpayers over $100,000 per month, please?
Senator Hussain, I won't allow that question.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, there are 3 questions on notice for response. The government proposes to respond to 2 of those questions, Madam President. That is question number 76 and question number 77. And we're respectfully asking, Madam President, for a deferral of the response to question number 78 for a 2-week period. Thank you.
Question number 78 is deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 76 to the Minister of Education.
Government Business.
Madam President, in responding to this question, this is something that happens within the school environment, and I can confirm that based on reports forwarded to the Ministry of Education by the School Supervisor 3, responsible for the Marabella South Secondary School, there was an incident on Wednesday, 4th December 2019, following the dismissal of the school at 2:20 p.m. A parent and his son were leaving the compound, and the parent, Madam President, was on the compound at the request of the school administration to collect his son, and that son was earlier involved in an altercation with another student. So we have a parent coming to retrieve his son, and that son having been involved in an altercation with another student earlier. As it turns out, Madam President, the student who was earlier involved in the altercation was now involved in a second altercation with the parent, and that necessitated the use of an ambulance to take that student to the San Fernando General Hospital. So that thereafter, in early January, the school and the Ministry of Education got together and set in place some protocols for the entry onto the compound, exit, the presence of visitors and parents, on the compound, vehicular traffic, the need to have a visitor pass, matters relating to parking on the compound and parking within the proximity of the compound, dress code, and so on. And all of that was meant to reinforce existing rules and protocols, to establish once again the standards for the operation of a school and the standard of conduct in a school environment, and to ensure that the opportunities for conflict and the opportunities for this sort of altercation and assault would be minimized. And it is a most regrettable and regretful situation, but unfortunately it does in fact happen. I would tell Senator Mark that I'm a proud product of Princestown Senior Comprehensive School a long time ago, and these things happened when I was in school. School authorities dealt with it with the support of the Ministry of Education, and in this case I'm quite happy to report that the school supervisor, the school administration, the Ministry of Education, the parents got together and addressed this particular unfortunate matter. I thank you.
Senator Mark.
Madam President, can the minister indicate to the Senate whether this matter has been closed and no action has been taken or preferred, I should say, against the parent involved in the incident?
Minister.
Madam President, I can say that the incident was reported to the Marabella police. The police officers visited the school following the incident, and the matter is being actively pursued by the police.
Madam President, can the minister indicate, the Honorable Minister that is, whether any action, disciplinary action, has been taken against the student who was involved in the altercation with the parent?
Minister.
Madam President, I'm not in a position to indicate whether disciplinary action has been taken against one or two or any of the students involved in this particular incident.
Senator Mark.
Madam President, would the minister be kind enough to provide in writing to this Honorable Senate a status report on this matter?
Well, you have to be a little more specific than that.
In terms of whether any disciplinary action has been taken by the school authorities or by the Ministry of Education or combined on this matter?
Minister.
Madam President, I would in fact undertake to do so in a week.
Next question, Senator Mark.
Thank you, Madam President. Question number 77 to the Honorable Minister of Energy and Energy Industries.
Acting Leader of Government Business.
Madam President, once again I thank Senator Mark for placing such a question on the order paper. There's a matter, if we do not provide absolute clarity, a lot of mischief could result. So I would say from the outset, Madam President, that it is not the gas, the LPG gas that has been increased. What has happened, we have LPG gas. So for example, if someone goes to an outlet, the gas station, the supermarket, or other places where the LPG gas is sold in cylinders, they would pay a particular price. And if the person wishes to have that gas delivered to their home by one of the private enterprises that do so, there is a transport cost that is added on by the delivery people. And the transport cost, the prevailing transport cost for delivery of a 20-pound LPG cylinder, as we say, the small tank, has been for a long time $4. In fact, the price was established in 2005. So for 15 years, the delivery people, notwithstanding increased cost of transportation, maintenance, labor, handling, logistics, have been working with this $4 delivery price. A decision was taken by the people who deliver to increase that price from $4 to $7 with effect from December 2nd, 2019. and that price has moved from $4 to $7. In relation to the delivery of the 20-pound cylinder, the small tank, I will, however, point out two additional things, Madam President. The first is to say that the price of the LPG gas remains the same, and in fact, Madam President, Trinidad and Tobago's price is actually 5 times lower than the prevailing price in the rest of the Caribbean region. In other words, if you're in Barbados, St. Vincent, St. Kitts, and one of those places, you would pay 5 times as much for a 20-pound LPG cylinder. That's the first thing. And the second thing is that for the larger 100-pound cylinder, the delivery price of that has not been increased. It's the same. So this question relates to the increase in price in the transport of LPG 20-pound tanks to your home for those who don't have the facilities maybe to go for it for themselves, or for those like Senator Mark who would like to sit luxuriously at home and have it delivered. The price, after 15 years, the transport people have added put an additional $3. For those who wish to avoid that, the opportunities to pick it up at the supermarket, the gas station, and other retailers still exist with no transport costs. I thank you very much, Madam President.
Senator Mark.
Well, I'm not. Madam President, can the Honorable Minister indicate what is the current price paid for persons who, like him, have to get these gas cylinders delivered, large cylinders? What is the current price? I don't have knowledge of it since I don't have that facility. So maybe he can tell us because he has that facility. Can you tell us what is the price?
Minister.
President, I must confess that because I still use the cast iron pots from the old days, I use an electrical powered single burner, and I also use a chulha. And I don't have the facility of the LPG, but I'm very familiar with LPG. I am very familiar with LPG gas. The 20-pound cylinder, known as the small tank, sells at $21 a tank, and the 100-pound cylinder sells at $105 a tank. And I emphasize that those prices have not changed. It is the transport of the $21 small tank, if you wish to have it delivered to your home, now involves an additional $3, which is not a bad price for it moved from 4 to 7. So you pay an additional $3 for having it delivered home after 15 years of the price remaining $4. I thank you.
Yeah.
Requests for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Haynes.
Madam President, I hereby seek your leave to move the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance, namely the failure of the government in managing the water shortage throughout Trinidad and Tobago during the COVID-19 crisis. The matter is definite as it refers to the critical situation resulting from a poor and inconsistent supply to a complete lack of pipe-borne water in all areas of Trinidad and Tobago for over a month, leaving entire communities with little or no option for an alternative water supply during a time when citizens have been asked to stay at home to stay safe. The matter is urgent as an innumerable portion of the population continues to suffer daily with no relief in sight, especially in providing such a basic and vital necessity as that of pipe-borne water. The matter is of public importance since the prolonged and widespread lack of an acceptable water supply, while we are currently experiencing a health crisis, where personal hygiene in the form of hand washing is now a life-saving action, and citizens are not able to access pipe-borne water, has left communities prone to public health hazards. Madam President, I thank you for your consideration in this critically important matter.
Honourable Senators, I have considered the motion and I am not satisfied that this matter, as presented, qualifies under this standing order. Honourable Senators, though, I want to take this opportunity to address and correct some of the misinformation that has been put into the public domain about motions such as these. Motions such as these have an extremely high threshold to cross in order to be allowed, because they have the effect of setting aside the business of the sitting, which has been prearranged and to which the sitting has already been committed. Permit me to quote from one of the leading texts on parliamentary procedure, and I quote now: "The right to move such a motion is hedged around with conditions designed to ensure that it is not lightly conceded. The matter raised for debate must require the immediate attention of the House and the government. The criterion creates a hurdle designed to ensure that the matter is of such substance that it justifies the House spending a substantial part of the sitting on debating it. Without a requirement that the matter be of sufficient importance to require it to be debated immediately, the scope of urgent debates would be enormous. There must always be such an element of urgency as would warrant precedence being given to a debate on the matter." These statements, as I said, are not mine. I have quoted from the David McGee Parliamentary Practice on New Zealand, and that learning is not inconsistent with the learning in Mays and other persuasive texts on parliamentary procedure, and is the accepted standard and practice across Commonwealth parliaments based on Westminster practice. The test, members, for allowing this kind of motion is not whether the matter is topical or interesting or dominating the media headlines. Members of this chamber should be aware that there are other avenues to raise matters which they wish to have the chamber consider, including the avenue of matters on the adjournment. And members in this chamber, at the end of almost every sitting, this chamber treats with at least 2 matters on the adjournment, private members' motions, and urgent questions. Honourable Senators, rulings made by presiding officers are required to follow the clear learning in this area, and correspondence and advocacy outside of the Parliament do not alter the applicable learning by which all of us are bound.
Madam President, may I crave your indulgence to return to item number 9, questions on notice, to indicate that the written response in relation to question number 105 has been submitted to the clerk for circulation to the members. Thank you.
Attorney General.
Good morning, Madam. Good morning, Madam President. Madam President, I beg to move that a bill entitled "An Act to Amend the Summary Courts Act, Chapter 420, the Oaths Act, Chapter 701, the Limitation of Certain Actions Act, Chapter 709, the Summary Offences Act, Chapter 1102, the Dangerous Drugs Act, Chapter 1125, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Shipping Act, Chapter 5010, the the Plant Protection Act, Chapter 6356, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7909, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, the Caribbean Industrial Research Institute Act, Chapter 8552, and the Motor Vehicles and Road Traffic Amendment Act 2017, Act number 9 of 2017, and to repeal the Magistrates Protection Act, Chapter 603, be now read a second time. Madam President, this particular bill, which is 20 clauses in length, amends 18 pieces of law, those being the laws that I've just begged to read by way of amendment a second time. This particular miscellaneous bill comes into focus largely on account of the COVID pandemic. As we are well aware, the COVID pandemic has been declared in this country to have effect by virtue of the Public Health Ordinance in the declaration of COVID-19 as a dangerous infectious disease, and secondly, by way of operational implementation of certain strictures, again using the public health regulations as we do under that particular ordinance. In these circumstances, we have need to cause amendments to our laws to better assist the country in the management of issues which arise from time to time. Certainly, the bill in its context has the effect of calling more people to do more work on some occasions, less people to do less work on other occasions, to find different methodologies and manners to actually operate in the virtual environment in particular, as we do a lot of meetings in the online presence methodology, to manage the amendment of the manner in which we receive our food, to manage the receipt of evidence for the purposes of criminal prosecution, to manage the filing of documents, to look, in fact, at the time limit for the filing of actions as well. That's in the general round context, some of the broad areas of this legislation that this bill proposes to have effect. Permit me, therefore, to jump immediately to the terms of the legislation. I would like to thank, in particular, the Law Association for sending in some comments at the very last couple of days. On the 3rd of May, we received a submission from the Law Association. I wish to express my gratitude to the President of the Law Association, Mr. Mendez, for taking the time to go through the legislation. Indeed, I've reflected upon that and certainly have received some benefit as a result of considering the law further. So let's jump directly to the law. Madam President, if we look immediately to the amendments that we propose to the Summary Courts Act, and we look at clauses 3 and 4, I had given an undertaking to this Honorable Senate when we were debating the magisterial protections to be found in the Magistrates Protection Act. We had cause to look at that parent act, Chapter 603. That's a law of 1917. It was brought around the same time as the Summary Courts Act, which is again a law in 1918. In debating the magisterial protections in that Magistrates Protection Act, we gave an undertaking to go back to the drawing board and to look at full magisterial protection. Why did we do that? Simply because, Madam President, magistrates are called upon in today's world, in the exercise of their summary jurisdiction, to exercise large powers. Those large powers, for instance, on a single judge sitting, are seen across the financial landscape. For instance, the Financial Institutions Act, many of our summary offenses, which can go either way. You're looking at magistrates exercising full and heavy powers, but they do so with very limited protection. Madam President, by amending the Summary Courts Act in the manner that we propose to do, we propose to give magistrates full protection of the law. The Law Association brought our concern that we should perhaps look for a different formula. I respectfully disagree with the Law Association's position because I'm comforted that judges, masters, have a particular form of immunity. It is full immunity. We instead prefer to carve out the recommendation that out of an abundance of caution, we are making sure that magistrates are still capable of appeal. There will be the regular appellate process, but I want to remind that magistrates are subject to judicial review, and therefore the purview of the Constitution, Section 14 of the Constitution applies, and also the Judicial Review Act applies, which is a situation different from judges and from masters. Madam President, if we turn next to the Oaths Act, the amendment to Chapter 701 in Clause 5, we are proposing here to modify the Oaths Act to remove the anachronistic reference to the distinction between a Christian and a Jew. That is no longer applicable in our point. We are allowing for the virtual operation of courts to prevail with the use of this act. The Oaths Act allows anybody who has the power to administer an oath, and that is by virtue of office or by way of consent of the parties, to administer the oath. What this does is to allow you to simply uphold your hand and swear to tell the truth. And therefore, lawyers who conduct the examination of their clients and cross-examination can have their witnesses sworn in a virtual hearing in their offices with ease now, courtesy these amendments by Clause 5. Madam President, we turn next to Clause 6, the exception of limitation of certain actions. We're proposing that the Attorney General have the ability in this particular COVID pandemic to allow for the extension of the period of limitation. Why? Even though Section 9 of the Limitation of Certain Actions Act allows you to argue that the limitation period doesn't apply to you. And what is the limitation period? Either 4 years or 12 years or such other period where the law says, look, for certain matters, civil matters, you have to bring it within a certain time. It's usually 4 years. If it's a judgment debt, it's 12 years. In these circumstances, even though the law allows you to go and argue that there was an intervening cause where the limitation period ought not to apply, we are now saying, let this be done by way of an order. The Law Association felt that the use of an order ought not to be the appropriate point. We respectfully disagree on the back that many of our delegated functions are extended by way of order. I can take you to the income tax regime, the companies regime, a number of different places. So number one, we rely upon Section 9 of the Act, which allows you to argue otherwise. Number two, in any event, the Attorney General acts on a cabinet decision. So pursuant to Section 75 of the Constitution and Section 79 of the Constitution, there is direct supervision of the executive function in making this particular launching pad, and therefore we are confirmed in our view that there's no breach of the separation of powers, if one could argue that. Madam President, we turn next to the animal diseases importation issues, and that is to look at also the cruelty to animals. Whilst we laid a very important bill in the Parliament, being the Animal Diseases and Importation Amendment Bill 2019, we did that on the 11th of September 2019. It's a very long bill. And in that bill, Clause 26 of that bill, the new sections 18A to L, we had the whole cruelty to animals, cockfighting, abuse, positions. We had that full gamut there. We felt it important at this point, whilst we had the opportunity in a miscellaneous bill to simply amend the Summary Offences Act to raise the penalty for cruelty to animals, because our society has demonstrated that it must be managed, if I can use that sense, in respect of its cruelty to animals. We have to do better, and therefore we proposed an increase in the fine to $100,000 and to a term of imprisonment of 5 years by an amendment to Section 79. Madam President, Clause 8 seeks to amend the Dangerous Drugs Act. What we're doing, when we amended the Dangerous Drugs Act with the cannabis issues in December last year, we had a cross-referencing error in the proofing that came from the Parliament, and therefore we now seek to amend Section 5B of that Amendment Act by correcting the sub-reference, cross-section references. Madam Speaker, Madam President, turn to Clause 9, the Mental Health Act. Madam President, we're seeking here to allow for the two streams of the Ministry of Health to operate under law under this act. That is the RHA stream and the Ministry of Health stream, and all that we are doing is something that should have been done a long time ago. The issue of mental health is very relevant in the COVID pandemic, and we need to make sure that officers are properly clothed in law to exercise the functions that they do. Clause 10 seeks to amend the Children's Act. Again, we gave an undertaking in the passage of the cannabis relief issues, the decriminalization of marijuana, that we would look at the issue of children. Pursuant to that undertaking, we now seek to amend the Children's Act. The Children's Act only allowed a constable to refer a child to the Children's Authority for possession of tobacco or alcohol, smoking tobacco or drinking alcohol. We think it important to include the possession of or using of a dangerous drug and substances having an effect similar to that of a dangerous drug. Our newspapers are replete with examples of people under pressure, of children engaged in positions like this, and we satisfy our undertaking to this Honorable House by making these amendments to the Children's Act by amending Section 38 of the Children's Act. Madam President, I turn to the Shipping Act. There was a very large issue of the shipping regulations not properly managing the party boats, the shipping issues around that. We have already drafted the amendment to raise a significant penalty for breach of those pleasure craft. And to do that, we need to amend the Shipping Act to give us the legislative power to raise the penalties by way of the regulations. Accordingly, we seek to amend Section 406 via Clause 11 to allow us to bring the regulations which we have already prepared into effect. Madam President, the next thing is Section Clause 12. This is courtesy the Minister of Agriculture. In the importation of food, we are basically having too much, bureaucracy, where we can, in fact, manage the process of phytosanitary risk factors in a different way. In other words, food being imported, things like canned chana, etc., we can remove a layer of bureaucracy by having the minister describe those products which actually require the use of that particular officer to clear goods, as opposed to every shipment being cleared by the use of the relevant officers from the Ministry of Agriculture and the food divisions. So that is Clause 12. Madam President, I turn to Clause 13. Clause 13 in the amendments to the Financial Intelligence Unit Act, we are looking specifically to improve the method by which we can enforce court orders. Currently, Section 12 and cross-referencing Section 18 of the Financial Intelligence Unit Act allows for an entity which is in receipt of a court order, an entity which is in receipt of a compliance position, to be brought before the court for failing to observe the order. What we propose is that instead of that being just on a summary level, where you must go within the 6-month period, we can bring it either way, either by way of a summary conviction offense to a fine of $500,000, or by way of conviction on indictment to a fine of $1 million. And this is where a financial institution or a listed business fails or refuses to provide information after they have been taken to the FIU takes them to the High Court for an order. Before the court is making that order, we're looking now to manage that process by improving the risk if you fail to observe the order. So this is what the amendment to Section 12 of the Financial Intelligence Unit Act does. It is to ensure better compliance so that the risk of money laundering, financing of terrorism, and the breach of economic sanctions is properly managed. I turn next to the philosophy that underwrites clauses 14, 15, 16, etc. That is the Financial Institutions Act, the amendments to the Income Tax Act, and the amendments to the Central Bank Act, as well as the prescription behind the philosophy. Madam President, in these 3 pieces of law, there is a strict requirement for secrecy or confidentiality. That secrecy provision, if we look at the Financial Institutions Act in Section 55, that secrecy provision has been hindering the advancing of criminal prosecutions, because the banks, the financial institutions, are taking a perspective that even though they are giving material under compulsion of law, where they have provided material by way of a production order under the provisions of the Proceeds of Crime Act, or by way of a warrant under the Preliminary Inquiries Act, even though those documents, materials, etc., are produced under the cover of the production order or the search warrant, they are not going the next step of giving a witness statement for the purpose of criminal prosecution. Why is a witness statement relevant? Because, Madam Speaker, in complex fraud matters in particular, the DPP has the ability under the Preliminary Inquiries Route, Section 23(8), to directly indict you, skip past a preliminary inquiry, indict you on complex fraud or other matters, and to do that, a witness statement is required for the purpose of admissibility of evidence. Now, the Law Association took the point of view that a witness statement needed to be defined. I respectfully disagree on the back and power of not only the Interpretation Act, but the Evidence Act, as well as the civil proceedings rules and the criminal proceedings rules, where a witness statement is defined, for instance, in the civil proceedings rules under Part 29.4 of the civil proceedings rules, and under the Evidence Act, where the reference to statement is made. So this is done in very careful circumstances where the admissibility is required for the DPP to receive evidence under a witness statement which only refers to matters, effectively, that have already been produced by way of compulsion of law, search warrant or proceeds of crime warrant. And therefore, the replication of the amendment to the Financial Institutions Act is put inside of the Central Bank Act and also the Income Tax Act. And therefore, we are within square lawful purpose in providing cover for the giving of a witness statement in these circumstances. It is intended, quite simply, to cut out preliminary inquiries whilst we move our way to abolishing them very shortly. There's still the methodology to allow the DPP to advance prosecutions and have people have their day in court so that they can either be acquitted or convicted by way of due process. So that underwrites the amendments proposed to the Financial Institutions Act, the Income Tax Act, and the Central Bank Act as clauses 13, 14, and 15 proposed in the legislation before us, the bill before us. Madam Speaker, Madam President, I apologize for constantly referring to you as Madam Speaker. Forgive me. Madam President, I turn next to Clause 16. Clause 16 proposes an amendment to the Securities Act. In the Securities Act, Madam Speaker, Madam President, we're looking to treat with a number of issues. Firstly, we're looking at the amendments that the Securities Exchange Commission themselves have requested. We're looking to improve the fines available under the Securities Act. In that context, we're looking at a breach of the regulations moving up from $1 million to $5 million. We are allowing that specifically because of the due process protection that is available. The securities industry has demonstrated that whilst they may engage in serious matters, the offenses yield poor results. And we need only look at the IPO issue that came to the fore. Coming out of that particular exercise, it was a clear observation that we don't have much time to, I'm sorry, Senator, I have very, very little time, so I'll take it in the course of contribution. We are looking at the limitation on the penalties. The other factor that we're looking at is that the caution to be looked at is whether this is excessive criminalization. The Law Association has asked us to consider that factor. We have. We rest our case upon sections 159 onward, 160, 161, etc. of the securities legislation. That particular provision gets us the comfort that any action taken by the securities industry, by the Securities Commission, is appealable to a court of law. And therefore, all rights are preserved in the due process environment. I ask you to note, Madam Speaker, Madam President, that we're not amending Section 156A, which is the scheduled, how should I say, administrative fines for breaches of the Act. We're not treating with that. The other important thing that we're doing in the Securities Act is we're applying the methodology of disgorging. And in disgorging, the term is intended to refer to what is well known in the industry, but it applies to profits which have been earned as a result of an unlawful act. And therefore, we are allowing the remedy of disgorging. It's a well-known remedy in law. Again, there is a due process provision provided in the fact that all of the steps taken, anybody aggrieved by a decision of the Securities Exchange Commission has the right of appeal to the High Court and therefore straight up to the Privy Council, Madam President. Madam President, I take it I end precisely at 11, yes? Thank you. Madam President, the Companies Act amendments, we're looking at a number of things. Number one, we're looking to extend the period for the filing of notices of charge. Form 33 of the Companies Act is where a statement of charge is filed. There's a time sensitivity for that. Under the COVID pandemic, a lot of people could not file the statements of charge in time, and therefore we are effectively giving a moratorium on the filing of the statement of charge. That is only notice to the world. Nothing affects the creation of the charge, either in law or in equity, and therefore the mere notice to the world is what we are extending in proper form. I should tell you, Madam President, that I intend to come back to Parliament with an amendment to the law very shortly to allow for the complete removal for signatures for these documents. In other words, then, that you will be able to file completely electronically all of your company's returns. We're also looking at that for the filing of deeds as well, Madam Speaker, Madam President, and that's because we have put in place the hardware and software and process requirements over the last couple of years, and we've digitized millions of records. Again, I'm coming back to complete e-operation in Trinidad and Tobago. It is by the implementation of plant, machinery, people, and processes. The other thing that we do in the Companies Amendment is a huge loophole. Companies, numbering somewhere about 80,000 companies on the register, active companies, a vast majority of them do not declare their shareholding. A company is incorporated, they never declare who the shareholder of the company is, and therefore, they argue their way out of beneficial ownership. We are therefore requiring companies upon incorporation or existing companies to declare, to issue shares and to declare their shares. And these, Madam President, have come about in circumstances where people are actually declaring dividends, taking their profits out of the company, even though they are not shareholders of the companies. So this is a plug to a massive loophole, which we've been working on for quite some time as it relates to beneficial ownership and proper legal information. Madam President, that is also the case of managing the risk of money laundering and the abuse to society. Clearly, this is something that we have to get moving in the right direction. I'd like to say the Law Association asked us whether the reference to pledge of a guarantee was appropriate. I'd like to remind there's several types of companies. Externally registered companies, non-profit companies, as we now have under that particular realm, also called not-for-profit companies under the Companies Act. We then have companies that are limited by liability, and when you're limited by liability, your liability can be limited either by way of shares, limited in liability, or unlimited, or by guarantee. And therefore, it is appropriate to make the reference to limitation by guarantee and the issuance of the pledge of shares, because a company that is limited by guarantee is saying, look, we, the following members, guarantee that if there's an event of winding up, liquidation, etc., we will contribute towards that, and then you state how much. For instance, 20 members of a company agree to be limited to $50 per person. But you've got to pledge that because it's a future interest. It's not an actual interest where you pay up for your shareholding the way you do in the issuance of shareholding for limited or unlimited companies. So I'm quite confident that sections 7, 8, 9, etc. of the Companies Act take us into the right realm, and that the reference to limitation of guarantee by declaring the pledge of the guarantee is an appropriate thing to be captured in this realm. Madam President, I've dealt with the Securities Act already, which is Clause 18. Permit me to go next to the provisions of the Caribbean Industrial Research Institute Act, CARIRI. Quite simply, Madam President, in Section 10 of that Act, we had the Industrial Development Corporation listed as a requirement for the composition of the board. Of course, the IDC no longer exists, and therefore we could not populate a board for the CARIRI, and we now have to amend the parent law to remove that reference to the IDC so that we can populate this by law. I'm very grateful we had a miscellaneous provisions bill, because otherwise we'd have to move a whole act of Parliament just to amend this to populate this board. Madam President, permit me to go next to Section 20, Clause 20. Clause 20 is intended to cause the amendments to the Motor Vehicle and Road Traffic Amendment Bill Act. We propose very shortly, I see that I have 5 minutes coming upon me. I'll take your notice now, Madam President.
Well, right now you have 6 minutes.
Thank you so much.
Yeah.
So I intend to use the time. Madam President, we have operationalized a radical transformation of the motor vehicle and road traffic regime and our court load. It is now known that the words are going to come out my mouth as follows. 146,000 cases per year in the magistrate's court, 104,000 odd cases of that load are simply motor vehicle and road traffic offenses. We have created a conditionality for the use of the limits. We are of the road, etc. We are now prescribing demerit point system and fixed penalty issuance systems, and we intend to remove on the proclamation of the U-turn transformation system piloted by my colleague Senator Rohan Sinanan. When we operationalize that, which we were ready to do since the 1st of April, but which we will do shortly, we want to now take care of the 80-odd thousand cases in arrears. In the courts, there are 80,000 cases in arrears. And in looking at that, we want to clear the backlog by initially offering a 50% sale, if I can use that expression, on the fixed penalty tickets that exist in there. That is therefore to move the backlog out. This will also have the effect, Madam President, of cautioning people to come in and clear tickets against themselves, lest they are brought before the court by way of summons or by way of warrant when they don't pay their fair share or comply with the law. And we warn that this law allows us to remove the limit from 50. We can raise or vary the limit to 75%, 80%, whatever it may be, to get people to comply with the law. Madam President, that in the round, therefore, allows us a fair perspective of what the bill is all about. That's all of the pieces of law canvassed, the Summary Courts Act, the Oaths Act, limitation of actions, summary offenses, etc. And there are a cross of issues. I give notice that we intend to come back to the Parliament in another miscellaneous provisions bill very shortly as we look to further amendments, specifically with the treatment of the magisterial districts. We are writing out now to stakeholders to ask them their views on judge-only or limited jury trials in this COVID pandemic situation. Thank the Lord that we have done as well as we have in the last couple of years by producing laws and operationalizing laws so that in this COVID pandemic, we have the ability to move seamlessly forward with our work whilst limiting the risk to persons as a result of the dangerous infectious disease. In all of those circumstances, I look forward to the contributions of learned colleagues at the debate stage and also committee stage, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Summary Courts Act, Chapter 420, the Oaths Act, Chapter 701, the Limitation of Certain Actions Act, Chapter 709, the Summary Offences Act, Chapter 1102, the Dangerous Drugs Act, Chapter 1125, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Shipping Act, Chapter 5010, the Plant Protection Act, Chapter 6356, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7909, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, the Caribbean Industrial Research Institute Act, Chapter 8552, and the Motor Vehicles and Road Traffic Amendment Act 2017, Act Number 9 of 2017, and to repeal the Magistrates Protection Act, Chapter 603, be now read a second time. Senator Mark.
Thank you very much, Madam President. Madam President, I'm very happy to contribute to this debate, but I must record what I discern to be a very dangerous trend that is emerging in this Parliament. I don't know if it's a strategy on the part of this regime through the Attorney General to use miscellaneous provisions or legislation to house scores of pieces of legislation for amendments. I think, Madam President, that is a very dangerous development. It is worsening by the day. Today, Madam President, we are being asked in a compressed environment as it relates to time, given the decision of the government, not by you, Madam President, by the government, to suspend standing orders so that we can speak less. But yet still, Madam President, we are being given 18 bills, 18 acts to amend in one miscellaneous amendment bill. If that is not an abuse of the parliamentary process, I don't know what is. And Madam President, what is even worse, we are being told by the AG that the Attorney General, that is the Honorable Attorney General, that it is connected to COVID-19. Madam President, the majority of these measures here has absolutely no connection whatsoever to COVID. But that is a strategy on the part of the government so that they can frustrate the opposition in properly scrutinizing in a qualitative way their measures that they have been introducing. Madam President, this bill that is before us today is what I would like to describe as a hodgepodge set of amendments crafted together without rhyme or reason. There is no discernible common thread running through the various bills that are before us or acts to amend, Madam President, being proposed, that is. Madam President, whilst there are few clauses that are related to each other, few, I emphasize, the sheer number of amendments to be considered by this Senate and the number of pieces of legislation involved seriously curtail the ability of any ordinary member of this Senate to properly and effectively scrutinize the legislation that is before this House, properly speaking. The restrictions on time, as I emphasized earlier, have also exacerbated the emaciation of our parliamentary process, a process which is meant to be the bulwark against authoritarian rule and dictatorship. Madam President, it is an indictment on this government and the sitting Attorney General as guardians of the Constitution that it would allow the parliamentary process and scrutiny to be undermined in this fashion. Even if legally permissible, Madam President, there are certain democratic norms and features, whilst not expressly protected by law, but which must be protected by the government, the opposition, the independent, and senators, and our parliament as a whole, Madam President. The bill before us represents a complete failure on the part of this government to protect the democratic norm and value of parliamentary scrutiny. Madam President, I heard the Attorney General in his contribution making reference to the Law Association submission, and he rejected every one of their submission. I would call on the Attorney General to table and circulate the Law Association memorandum to him so that we in the Parliament would have a better understanding of the thinking of the Law Association. It cannot be that the Law Association, which is the body representing lawyers in this country, making proposals to the Attorney General, and he's just throwing them out of the window, whimsically and arbitrarily. So we demand that the Attorney General table the Law Association correspondence. Madam President, as I move on, let me indicate very early that we spent a long period of time in this Senate debating the Magistrates Protection Act. The government had come with some amendments, Madam President, that were totally unacceptable at the material time. And we fought the government, and we were able to compromise. We arrived at a compromise. Here it is, after almost 1 year, the government returns, through the Attorney General, to take immunity out of the protection of the Magistrate Protection Act, place same under the Summary Courts Act, Madam President, and like a dictator, simply propose an amendment, not an amendment, Madam President, the repeal of the Magistrate Protection Act. Madam President, this is not only dangerous, it is reckless, highly irresponsible for the government of this country to remove protections that we have in this act for ordinary people and give a blanket immunity, a total immunity, a full immunity to magistrates. So, Madam President, a magistrate is not a judge. A magistrate has certain limitations in terms of jurisdiction. And if a magistrate, as we debated in that matter that we dealt with a couple of months ago, when a magistrate goes outside his or her jurisdiction and maliciously, deliberately, and intentionally prosecutes someone innocently, and that person winds up in jail, that person must have the right, Madam President, to take personal action against that magistrate, because that magistrate has gone out of the limitation and jurisdiction. And therefore, we do not support this amendment that the government has put forward to give a total and full and blanket immunity to magistrates in this country. And we will be moving an amendment to that provision, Madam President. This is dangerous legislation that we are dealing with under what is called the cover of COVID-19. It's almost like a grab for power on the part of this administration.
Mark.
Madam President, I understand,
yes,
and I will calm down.
I have to caution you at this
Yes,
stage.
I will calm down. But I feel very strongly, Madam President, about some of the provisions here.
And while you feel strongly about it, Senator Mark, you have to remember the language that is required in this chamber.
I understand you, Madam President. Madam President, I know an election is going to be called very shortly, and we will have the opportunity to deal with it on the platform. Madam President, look at Clause 6, Madam President, with me. The AG, Madam President, we have no problem with what is being proposed here during this COVID period. You have to cover these people in terms of the limitations, the Limitation of Certain Actions Act. But what we have taken place here, Madam President, is the Attorney General, without the permission of this Parliament, arrogating unto himself the power, Madam President, to extend the period, Madam President. And Madam President, we are saying no. We are saying we do not believe that the Attorney General should have that power. And therefore, in those circumstances, we reject that arrangement. And why are we putting the Attorney General in this law? Or such longer period as the Attorney General, whoever that Attorney General may be, by order. Madam President, I agree with the Law Association. there is a concept of the separation of power. Under Section 75(1), the executive is accountable to this legislature, and only the legislature can make laws. We can delegate laws to be made, like regulations, by the government, by the minister, but we cannot give the Attorney General blanket power to make laws as is being proposed. So I want to serve notice on the Attorney General. You are not a lawmaker on your own. You can only be a lawmaker within the framework of the legislature, and you cannot go out there and make laws on your own. That is unacceptable, and therefore we reject that concept. And that is repeated in the Companies Act and its amendment, where the Attorney General is arrogating unto himself powers of the legislature. He does not have that power. We will not give him that power. He cannot have that power. And therefore, Madam President, we serve notice on him and this Honorable Senate that we will have an amendment to this particular matter here. And I know that you have already advised me. Put it in writing so I understand that, Madam President. Madam President, I want to ask for your kind indulgence. Madam President, I tried. Honestly, I tried to see the links, the connection, the inextricable relations between what is in clauses 14, 15, 16, 17, and even clause 18. But more so, the Securities Act, Madam President. And I couldn't find the connection to COVID. Madam President, the provisions contained in these bills, these amendments, whether it's income tax, central bank, whether, Madam President, it is financial institutions, whether it has to do with central bank. We are trying to determine, Madam President, the provisions in the bill before us, 14, 15, and 16 in particular, seek or purport to make exceptions for confidentiality requirements in the various pieces of legislation, which, Madam President, rightfully attach criminal sanctions for breaching confidentiality. Madam President, in the ordinary case, if information is provided to one of the authorities, that is, public authorities, particularized by the bill, an employee or an officer of that department cannot disclose that information, save and except in limited circumstances. Madam President, what these amendments to sections 14 or clauses 14, 15, and 16 do is to bring through the back door, without any safeguards, without any checks and balances, whistle-blowing legislation. This is whistle-blowing legislation through the back door. This is what the Attorney General and the government is doing in clauses 14, 15, and 16. What this bill introduces, Madam President, is an unacceptable level of vagueness by attempting to widen the category of instances where an officer or employee of these institutions, be they BIR, be they central bank, be they commercial banks, Madam President, to permit those employees and officers to disclose information to the police. Madam President, most disconcertingly, the concept of information, and I have a case study that I've looked at, Madam President, as a bush lawyer. And I can tell you, Madam President, confidentiality of information in a Supreme Court judgment in the United Kingdom has been ruled as property. And property, Madam President, is a constitutional right that every citizen has to enjoy. So no officer or employee or officer of any institution mentioned in 14, 15, and 16 would have the power to just give information. My private and confidential information is property under the Supreme Court of England case involving the Revenue Department in the United Kingdom. So I want to warn the Attorney General, you are on a constitutional collision course, and you better back and withdraw. Otherwise, you will end up in court, because you are dealing with the rights of citizens when coming to these sections. Madam President, the concept of information being available to the public, and that is what they are putting out here in 14, 15, and 16, is a repertoire, a repeat of everything they are saying in 14, repeat in 15, repeat in 16, and so on. Madam President, from other sources, that is, information being made available to the public from other sources, is being introduced as being an exempted category of instances where ordinary confidentiality requirements do not apply. That is what is being emphasized in these amendments. Firstly, we want to ask the Attorney General, what precisely does it mean when one says that information has been made available, Madam President, to the public from other sources? What does the Minister, the Honorable Attorney General, mean by this? Do we mean information that is within the repository of a public body, as a central bank, as a BIR, Madam President? So, for instance, if private financial information was provided by me, Madam President, to a public authority, BIR, does that mean it is now open to an officer of the BIR, for instance, to disclose that information to whoever they see fit? I ask. This is what the Attorney General is implying and is in the law that is being proposed here. In that case, Madam President, the BIR, that is the Board of Inland Revenue, is a public body. So so is the central bank, Madam President, a public body. Such a broad interpretation would render almost meaningless, Madam President, any confidentiality requirement in the legislation. In other words, Madam President, all of the information that the BIR has would automatically be disclosable by any employee or officer of these organizations. That is what we are being told and asked to support. And here, Madam President, the sanctions for breaches of confidentiality have an important purpose. The law, Madam President, the law, AG, the law recognizes not only that information constitutes property, but that a citizen has a constitutional right to privacy. So it's not only property we are dealing with, Madam President, but we are dealing with the right of a citizen to privacy. And if you are going to invade and intrude privacy and property rights, you better bring a certificate to attach to this piece of legislation. Otherwise, you'll end up in court. Madam President, the second exception is perhaps even more troubling than what I've just said. The exemption for witness statement to police. That is what the Attorney General just addressed. Are troubling. Information regarding finances provided to institutions such as the Board of Inland Revenue have been historically protected in law. It is disclosed for a specific purpose and ought not to be amended, save and except by explicit wording in legislation. The proposed measure is not explicit. It is vague. It creates exemption. Madam President, the whistleblower is now exempted, Madam President, from liability, but does not expressly amend the position that confidential information provided have specific purposes and ought not to be disclosed. Madam President, I want to refer the distinguished and learned Attorney General to a judgment of the Supreme Court, which will be used as evidence in the courts of Trinidad and Tobago if he dares pass this bill in its current form. Madam President, you know what it says? This judgment was delivered on the 19th of October, 2016. And Madam President, it involves an application of Ingenious Media Holdings, appellants versus commissioners for Her Majesty's Revenue and Customs as respondent, Madam President. Madam President, the Supreme Court of the United Kingdom in this matter, which was dealing, Madam President, may I advise, the appeal concerns the scope of duty of confidentiality owed by Her Majesty's Revenue and Customs in respect of the affairs of taxpayers, Madam President. Firstly, the court articulated the well-established duty of confidentiality that public authorities such as the BIR, such as the central bank, as examples, Madam President, have when they receive confidential information from members of the public. One particular judge on that panel called Lord Tolson stated, and I quote, Madam President, the duty of confidentiality owed by the HMRC to individual taxpayers is not something which sprang fresh from the mind of the legislative drafter. It is a well-established principle of the law of confidentiality that where information of a personal or confidential nature is obtained or received in the exercise of a legal power or in furtherance of a public duty, the recipients, whether they are the BIR or the central bank or at a private bank, will in general owe a duty to the person from whom it was received or to whom it relates, not to use it for other purposes. Madam President, it goes on. The principle is sometimes referred to as the Marcel principle after a case involving Marcel and the Commissioner of Police. Madam President, I have brought these matters to your attention and to this Honorable House, Senate's attention to show how miscellaneous bills with 18 amendments to legislation can hide very dangerous provisions from you and me if we do not have the time, Madam President,
Senator
to
Markey.
properly scrutinize it in the detail that we need to do it, given the time compression that we are faced with right now, Madam President.
Senator Mark, you have 5 more minutes.
Thank you, Madam President. Madam President, Lord Tolson warned governments like the one we have in Trinidad and Tobago against the use of this information for a collateral purpose. And that is what the government is attempting to do with these amendments. Madam President, I just want to burden you with one final quotation from the eminent Lord Tolson in this very famous judgment by the Supreme Court. He said, and I quote, "In relation to taxpayers, HMRC's entitlement to receive and hold confidential information about a person or a company's financial affairs is for the purpose of enabling it to assess and collect or pay what is properly due from or to the taxpayers." That is what it's about. The whole system, Madam President, involves that. Matters relating to income tax are between the commissioners and the taxpayers concerned, and that the total confidentiality of assessment and of negotiations between individuals and the revenue is a vital element in the working of the system. Madam President, our Constitution, Section 4C in particular, protects the right of the individual to respect for his private life. And private life, Madam President, involves the right to privacy. The common law has already shown that it protects confidential and private information given to the BIR or other public bodies, including the central bank. And Madam President, we are advancing and positing very, very firmly and seriously that it would be totally unconstitutional for the government to decimate the constitutional rights of citizens who provided information to public authorities with the expectation of confidentiality to allow the disclosure of information in the manner that the government is proposing. Bring a constitutional majority. You are inflicting and infringing rights of citizens to privacy and to property. And therefore, we have no right to allow such legislation to pass without the insertion of the certificate, Madam President. Madam President, it is clear that the bill in its present form, if not amended, if not have inserted a certificate of a three-fifths majority, is bound to lead to a constitutional collision and an inevitable challenge in the courts of this country unless these offensive, dangerous, and obnoxious clauses are withdrawn by this government through the Attorney General, Madam President. Madam President, in the few moments I have at my disposal, may I also alert you to the fact that we too, like the Law Association, believes that the Attorney General is being given too much power, and he has no such authority to have it, given how our Constitution is structured. We also agreed with the Law Association based on what the Attorney General has said, that the fines that they have imposed under clause, Madam President, may I find that clause for you? I think dealing with the Securities Act, where they are seeking, the Securities Act, clause 18, Madam President, where they are seeking to impose a fine of $5 million. We find that to be very disproportionate, given their powers. So we believe that is something that we ought to deal with. And we also want the Attorney General to tell us where in this document that we have before us is there a definition for witness statement. And finally, Madam President, information is different from evidence. Madam President, I thank you very much for the opportunity to speak on this very important matter.
Senator Thompson, aye. Honourable Senators, while I await Senator Thompson-Aye, may I just remind members that if you have amendments, that those amendments need to be reduced into writing and circulated by the time we come to committee, please.
Thank you, Madam President, for so graciously affording me the opportunity to speak to yet another bill brought by this Honorable Attorney General, indefatigable, irrepressibly exuberant, and amazingly articulate Attorney General. This bill that he has piloted today has a long, long title. Suffice it to say that the short title, Miscellaneous Amendment Bill 2020, is what we're dealing with today. Why has he brought this bill? Why now? What is the justification for the Attorney General having us depart from the injunction of the Honorable Prime Minister to stay at home, cook your food and bake your bread, the Minister of Health and the Minister of National Security's call for social distancing, and the Ministry of National of Agriculture's suggestion that we plant the land, all of which I have been faithfully adhering to? We have been brought here, but we have not had the justification that was given in the other place. We're told that it is, in fact, because of the COVID-19 pandemic, and better to assist the country in matters that from time to time have arisen. Interestingly, what was said in the other place, I would have expected that since it's the same bill, that the rationale would have been the same, and that we would be able to better understand why we are here, and the fact that it was said that it was because of the need for efficiency and the need to deal with a number of things that needed treatment. And they couldn't wait because it was very important that they be dealt with, that in fact is what has brought us here. Now, as an aside, I just want to say the reason I tried to stop the Attorney General when he was in mid-flight is because he was quoting Clause 16, but in fact, he was reading from Clause 18. That was all. Now, we've had a number of legislation that has been amended. And one of the very first that has been amended is the Summary Courts Act, Chapter 420, an act relating to procedure in respect of offenses punishable on summary conviction. And that was amended by inserting Section 159, which deals with the magistrate's protection. And Senator Mark has spoken about that, and I personally have no problem with it. But in that same act, if you're looking at legislation, and you're looking at legislation which needed the attention of the legislature, I expect that we would look at it in a holistic fashion. And in that same legislation, the interpretation section, and that legislation is dealing with an act, the long title, relating to procedure in respect of offenses punishable on summary conviction. And summary conviction, we're talking about adjudicated upon by magistrate. So in that interpretation section, there is a definition of child which says any person who, in the opinion of the court, before whom he appears or is brought, is above 7 and under 14 years of age. Now, that same interpretation section was amended by the Children Act so that we could have the maximum age of 18 for a child. But the minimum age is not being interfered with. I raised that point yesterday, but as usual, the Attorney General ignores me when he thinks it's convenient for him to do so. So that young person was amended, but child was not amended. And that original legislation dates back to 1918. We have amended our Children's Act. We have a new Children's Act dating back to 1925. And we still have not touched that legislation so that our minimum age for criminal responsibility is still 7 years of age, which is the common law age. So in 1925, when we put this Children Act on our books, England had that age at 7. They changed it in 1933 to 8. They changed it in 1963 to 10. And we are still holding on to that age of 7 years. We looked at the legislation again, and yet we have not touched it.
Senator Thompson, if I could just point out to you that you're talking about amendments that you think should have been incorporated in this miscellaneous bill. So you are not being relevant to the matter at hand because you have to treat with what is in the bill, not what is not in the bill. Okay? So I would ask you to move on to another point.
Thank you, Madam President. I was actually responding to the crying out for remedy that the Attorney General said he has brought these provisions to the Parliament.
Senator Thompson,
Yes.
I understand, but I would just ask you please to just heed the advice and perhaps move on.
The legislation in respect of Cruelty to Animals, Summary Offences Act, has amended, that act has been amended so that the provisions, the penalties have been increased from $400 to imprisonment for 2 months. And again, you have increased it to $100,000. So we have increased the penalty for offenses against animals, but again, I must say, not offenses against children. Madam President, when we look at the number of pieces of legislation that have come here today, I would like to say that we have missed a glorious opportunity to do what we can for children. This is a situation where we're talking about COVID and the impact on the community, and that is why we have brought this legislation. And I would really like to make the point that just as we talk about domestic violence in terms of spousal violence, we must not forget that domestic violence affects children. And we have done nothing insofar as children are concerned, except the offense of drugs, dangerous drugs, but we have done nothing to protect them in a situation where they are liable to be damaged severely by their parents. So we have a number of, as I say, offenses here. We have a number of pieces of legislation, and I do not accept that what the Attorney General has said is that they are important because of the COVID situation, and that's why we have brought them here, and we have lost a glorious opportunity to actually deal with a number of deficiencies in our law to protect our children. So I am constrained by your ruling. I had many suggestions for the improvement of this bill. And since my suggestions have not been, in fact, despite promises over the several months, been adopted, I can only say that I rest my case.
Thank you, Madam President, for recognizing me this morning to contribute on this miscellaneous provisions bill, which touches and concerns many, many standing pieces of legislation that we have. Now, Madam President, I'd like to jump directly into the bill because there's a number of things that I wish to touch on. The first would be the clause 6, which deals with the Limitation of Certain Actions Act. Now, I understand the provision itself. My only thing, because I am fully aware during this particular COVID-19 period, many persons would have filed or attempted to file certain actions before the court that were not deemed fit for hearing based upon the reasoning set out within their certificate of urgency. And some persons, in terms of the description in their certificate of urgency, would have placed the limitation period as a measure for that urgency. So I think this is extremely comforting that the time period has been extended. I was just simply wondering whether or not the government would consider, and the Honorable Attorney General would consider possibly extending it a bit longer, because there are certain practitioners before the court who are also having difficulties with respect to taking instructions from clients during this particular period of time based upon the COVID-19 situation, and they may run afoul of the limitation period. I would jump to clause 7. The Honorable Attorney General and I would have had a discussion on this. I think it's well deserved. There are many crimes that have been committed against animals within the recent past. And I think for some time now, this particular piece of legislation would have sat on our books without a sober look at increasing the penalties prescribed to persons who would run afoul of this particular offense. And I know in terms of discussions, I definitely would have raised the issues regarding cockfighting as well too, because there are many other illegalities that accompany cockfighting as well. For example, illegal gambling would be at a cockfighting ring, firearms, drug possession, even human trafficking as well too. So that would be something that I think we could look at in future as well. I looked at clause 13, which deals with amending the FIU, and I understand in terms of increasing the fines and penalties which the bill prescribes. The difficulty is that in terms of my discussions with many members of the business community, it has been felt that there should be also some strengthening of the FIU as an institution itself as well. Some of the requirements that are asked by the FIU of business persons, registered businesses with the FIU, would involve these business entities procuring information and also verifying some information from some third-party persons. In those instances, it places the businesses at a precarious position because they have these short timelines to complete these activities within. And I am told, I am informed by these businesses that they are not getting the relevant support from the institution as they should to complete the activities that they have been tasked with. So that an increase in the fines, albeit that it is welcome, because I do agree that there are some businesses, as limited as they may be, that shirk the responsibilities in terms of complying. I mean, I would have read up on the report generated by the FIU for 2019, and it demonstrates that they are doing a lot of work, a lot of the work that is actually done within this parliament, a lot of the laws that have been passed have been utilized by the FIU as well too in their fight against money laundering and other illicit activities. But we should also consider strengthening the institution so that persons can comply properly before possibly an increase in fine, or we do it as simultaneously as we can. Also, some of the requirements that the businesses have indicated to me requires them to conduct certain checks that they claim place them in positions of danger, because some of the individuals that they have to treat with and run some background checks pursuant to the database provided by the FIU possibly involves them interacting or placing them in harm's way by informing on these individuals who could possibly be involved in illicit activity. And so some business persons believe that maybe this particular activity should be adopted specifically by the FIU itself and not the business community. And so maybe by strengthening the institution, providing them with more bodies, more personnel, more plant, equipment, and machinery, they may very well be able to do these processes on their own and not have the business community get involved in that. Now, I jump to page 11, page 10 and 11. So the amendments to the Companies Act. Now, I, as a practitioner, I do a bit of company law myself, and I know the Honorable Attorney General in his practice as well too before was heavily involved in company law. So this is going to be quite academic. I know in terms of shareholders, so I listened intently to what the Attorney General indicated in terms of his presentation. This is supposed to be geared towards identifying in my estimation, the sideline beneficial owners then. So you would have a situation where a company is incorporated, you have the actual listed shareholders who may number 10 or 15 or whatever, and then those shareholders now, or even maybe So those shareholders, let's say it's 3 shareholders because it's within a family business or whatever, they have sideline arrangements with X and Y, would provide them with capital funding, but are not listed on the company's registry as an actual shareholder of the company. And even though companies are called to task through their annual returns to demonstrate who these shareholders may be, in most instances they don't identify who these sideline backdoor deal beneficial owners are. What I'm trying to understand by the wording of this particular section and this amendment, I'm not 100% sure if this will capture those persons. Because I listened, it was the first time for me that I heard the term company for profit. The company shall issue share capital or pledges by way of guarantee. And I understood in terms of the definition given by the Honorable Attorney General that these guarantors are supposed to be the persons who would guarantee a figure or sum towards the debt in the event of insolvency, which I was a bit shocked to find out that we actually have a system set up in Trinidad like that. But then these shareholder guarantors then may not very well be the sideline beneficial owners that we are trying to capture with this particular situation. And then I thought to myself, I telephoned another colleague of mine who does a lot of company law, and we were thinking whether or not possibly saying then, because issuance of share capital usually occurs subsequent to a board of directors meeting, then it would be a meeting at an AGM or an SGM where the shares, the right of choice, the first choice would be given to the actual shareholders of the company if they want to purchase more shares to raise capital for the company. And if those shareholders refuse, then you go outside and you look to procure capital from other individuals who would then become shareholders. So we were thinking whether or not maybe there could be this compulsion to register those persons could be done after every single AGM or SGM where that decision with issuing new share capital could occur. The problem is, it could become extremely onerous for very large companies if they had to do something like this. But then equally, there's no real way of figuring out if they will be truthful or honest in terms of their declarations, because if they don't do so in their annual returns, then how can we compel them to do so by the wording of this particular amendment? And then they are not necessarily going to be captured by this because they may not very well be the guarantors, based upon what I understood. So I definitely would like some significant clarity, because there are many, many companies within our country, especially in terms of my reading, when it comes to money laundering, where a lot of money launderers worldwide will look at countries that would have weak company registration laws and high access to foreign exchange to launder money in those countries. And those are the beneficial backdoor owners that we should definitely try to capture, because they are the ones who are investing these monies, getting their profits paid out to them in cash and whatnot. And if we are trying to capture them as persons of interest, I am not 100% convinced, especially by way of conversation, that this may very well be able to do so. I definitely would look forward in terms of the committee stage, and even in winding up, if the Attorney General could definitely shed some light. I know that you have experience within that regard. Apart from that, I think we definitely need to pay attention to some of the other pieces of amendments within the bill itself. I know that honorable colleagues would pick up on certain points by way of their contributions. I would definitely like to hear on the issuance of the limitation period possibly being extended, and I definitely look forward to a discussion on the other elements of offenses against animals, because that is a very close thing to me as well, to being the owner of pets myself. With those few words, I thank you, Mr. Vice President.
Minister in the Ministry of Finance.
Thank you, Mr. Vice President. Mr. Vice President, this bill, the Miscellaneous Amendment Bill, is quite a long and involved bill, but I will deal with one particular aspect which covers several sections in the legislation. And that aspect has to deal with how we treat with financial crimes. Now, our society for ages has been imploring that the government pay more attention to what is commonly referred to as white-collar crime, because a lot of expenditure and effort is put into dealing with the other types of crime, the physical crime, the shooting, the rapes, the kidnappings, and these things. But white-collar crime is something that we have not made the kind of dent in that we need to make. We need to give some focus to that. One, to build the trust of the rest of society who are thinking that the people with means tend to get away with their crimes while the people without means are made to suffer and pay. And it also ensures that we protect the fabric of our society. So, Mr. Vice President, financial crimes are, we need to understand they are more facilitated by the use of fintech, ICT, cryptocurrency, e-payments, e-transactions. One of the things that this COVID pandemic has forced us to recognize is that the world has to make a jump forward. Trinidad and Tobago in particular has to make a jump forward in the use of these technologies. We have to look at things like increasing our ICT capacity and use, e-payments, e-transactions. We have to consider the introduction of fintech and cryptocurrency. But on the other side of that, we need to acknowledge that these things will more greatly facilitate people who are criminally minded to conduct financial crimes. And so we have to put things in place to deal with that expected ramp up in financial crimes. Money in today's world can be transferred in seconds globally. And this fact greatly complicates the task of criminal investigators in identifying and investigating such crimes, catching the criminals, and successfully prosecuting them. Money laundering, in particular, is facilitated through both offshore havens and often unwitting bona fide local financial institutions. When one understands that money laundering is a crime on top of a series of different crimes, one understands the significance of the problem. Because when you're talking money laundering, you are talking about something that comes after trafficking in drugs, trafficking in arms, trafficking in human beings, and contraband items. It also comes after activity that involves misuse of public funds. And so money laundering is just a symptom, just a layer of crime above a whole slew of things that we have to seriously deal with and try to curb. It is estimated, Mr. Vice President, that money laundering is estimated to be the third largest industry in the world, globally, on an annual basis, generating movements of funds in the vicinity of 500 billion to 4 trillion US dollars. It is a significant industry which has to be clamped down. The methodology and typologies of money laundering have become increasingly more sophisticated and more elusive, particularly with electronic transfers and internet banking. This requires us to give law enforcement officers who are dealing with financial crime a greater ability to effectively deal with that. At the moment, Mr. Vice President, their ability to deal with money laundering, with financial crimes, is significantly hampered by their inability to easily access information in respect of these crimes. When one understands that the ultimate goal in any financial crime is to convert illicit cash, to conceal the true ownership or source of the illegally procured funds, and to create the perception of legitimacy of the source of the funds or the ownership of the funds, one realizes this is a complex area that needs a solution to reduce the level of complexity so that we can put together a compelling case for presentation to the courts for prosecution of these criminals. What it requires, therefore, Mr. Vice President, is that investigators have access to information that is available, but not available to the investigators easily. So what we are seeking to do in this bit of legislation is to give law enforcement a fighting chance to successfully prosecute criminal financial crimes in Trinidad and Tobago. We have done that, for example, in Clause 14, where we are seeking to amend the Income Tax Act to, while we continue to preserve the right to privacy of the taxpayers' information, we are seeking to give restricted access to law enforcement to secure information from the various institutions, including the Board of Inland Revenue, to allow them to amass the kind of evidence they need to get to successfully prosecute criminal offenses. So we are seeking to add a Clause 4A to Section 4 of the Income Tax Act that will allow for an exception to the privacy rules. So we are preserving the Inland Revenue's obligation to keep taxpayers' information private. But what we are seeking to do is to allow them to disclose summary information. So, for example, they won't say, what is the income of Mr. A, but they will say, this sector of society, whatever it is, the petrochemical sector, for example, is generating this kind of activity, so that it gives the law enforcement a profile that determines, is this something that we need to look more closely into? It also allows for the disclosure of personal information, but only in certain very limited circumstances. So it would allow an employee of the Board of Inland Revenue to provide a witness statement to the police at the level of a superintendent or above in respect of a criminal investigation or criminal proceedings where the witness statement relates to information disclosed under compulsion of law, and it is requested in writing after prior approval is received from the DPP. So we are excluding political interference. We are ensuring that this is overseen by a senior officer in the police and by a constitutionally protected individual, being the DPP. So only in those very limited circumstances, Mr. Vice President, will the Board of Inland Revenue be allowed to be permitted to provide information on the taxpayers' affairs. And this is to allow us to better control the scourge of financial crimes. Mr. Vice President, what we have is several institutions that collate different aspects of financial information, but there is no one who has ready access to these different sources of financial information, and therefore they are not able to put the picture together that allows for successful prosecution. So what we are seeking to do is to allow a senior officer in the police, because we do have a financial crimes investigation unit that is at the moment hamstrung by these privacy provisions. So a senior officer in the police service, under the instruction of the DPP, we are allowing him to access information from these different sources so we can build a picture and build a case to give us a fighting chance to successfully combat these criminal offenses. So the Board of Inland Revenue is one of the institutions which has significant information, and we are seeking to get access in the limited circumstances that I would have outlined. Another such institution is the central bank. The central bank privacy laws provisions are so all-encompassing that it is impossible at the moment for the Minister of Finance to even know how much is being paid in remuneration to employees of the central bank. It is that extreme. So we are seeking to get limited, again, access to information from the central bank for the purpose of prosecuting criminal offenses. We are not seeking to erode the protections available to these various industries, but to give us, as I said, a fighting chance to deal with criminal offenses. The Financial Institutions Act currently prohibits licensees, financial holding companies, controlling shareholders, directors, etc., from disclosing information relating to the business or affairs of a customer. Again, we are seeking to get limited access to information of that sort to allow us to fight financial crime. Similarly, under the Securities Act, we have restrictions on our ability to access information, and these restrictions on these important institutions in sharing information puts a huge obstacle in the way of our Financial Investigations Unit. Now, if we look at the statistics, in Trinidad and Tobago alone, the FIU over the period 2016 to 2019 identified a total of $25 billion in suspicious transactions. $10 billion of those suspicious transactions were completed. 15 billion were identified before completion and therefore were stopped. But imagine how much more effectively that could happen if we were able to share information in the possession of these various actors, in the possession of these various institutions, which now have such severe secrecy provisions that they are not able, even if they're willing, to share the information. So even in its limited capacity, and with its limited information, the FIU was able to provide law enforcement with sufficient information during this last fiscal to prosecute certain activity. So the FIU has assisted the police during 2019 in providing financial intelligence and asset tracing in 58 money laundering charges against 18 individuals. It provided intelligence in support of investigation of seized cash and allowed the TTPS to investigate 40 cases where they were able to recover $3.9 million TT and 325,000 US. They also facilitated the customs and excise in 50 tax avoidance measures that led to the recovery of $24 million. Now, when we look at $24 million, 3.9 million TT dollars, 25,000 US dollars, when you compare that with the total, thank you, Mr. Vice President, when you compare that with the total of $25 billion in suspicious transactions, you realize that what we are doing currently is just scratching the surface in terms of successful prosecution and recovery, and we have to more significantly make a dent in that area. So, Mr. Vice President, the only way Trinidad and Tobago will have any hope of success in dealing with financial crime, which, as I said, is likely to become more and more prevalent as we move more into an ICT control space, is to allow the various institutions that separately have bits of information on people committing crimes to merge that information in a central location, properly controlled and properly managed, to get a whole picture that would give us a fighting chance in combating these crimes. Senator Sobers, I agree with you. We do need to strengthen the institutions, especially in the ICT field, and that certainly is going to be a focus of the roadmap committee that we're working on. But without the support of the provisions that we are seeking to get passed here today, we will not be able to make the kind of dent we are seeking to make. So I urge you to support these measures. We need them desperately, and I look forward to the passage of the bill. I thank you, Mr. Vice President.
Senator Dayal Singh.
Thank you, Mr. Vice President, for allowing me to present this bill. And I must say, I have to express the same sentiments as my colleague, expressed before Senator Ahi. She wanted to know why we came here today. What was the rush, the need? And at least she was trying to say, yesterday we understood the effect that we were discussing, the fact that COVID could affect domestic violence and could affect even the prison, population. But she was trying to figure out what was the rush for this omnibus, bill, with, I think you have 17, 18 parent acts that we are studying. But as it may, I am trying to relate some of that with what we are discussing, some of the issue why we are here today. And I can see basically that, even though we are here, we have to at least not only think about our lives, but the lives of the parliamentarians and the staff and support staff, but we are here, and I'm trying to get that connection. And so far, I have looked at something that I see here as a connection whereby during this period, we have an increase in admissions to the St. Anne's Hospital. We have an increase in persons with psychiatric illness. We have persons who are trying to reach out. And you see, Mr. Vice President, I look at clause 9 of the bill, and I look at clause 9, and clause, which looked at the Mental Health Act, Chapter 2802. And it actually sort of looked at who is a duly authorized medical officer in terms of being able to assist in this treatment of mentally ill patients. And I must say, as the Secretary of the Association of Psychiatrists, I think this was long in coming, and I congratulate the government for bringing this, because definitely we needed some clarity. There was a case where a mental health officer went to get a public officer from a building, and that actually went to court. That had some legal implications. And at that time, when the mental health officer went into this building, it was a problem we had where mental health officers were now scared to go and apprehend patients who are mentally ill. So you can imagine if you have a patient in a building that under this COVID stress it out, and you call a mental health officer to come into a home, they may say no, they are not qualified to go in unless it's a public space. So there are a lot of little things we need from the AG's department and the Law Reform Commission to beef up this act. So I welcome this Mental Health Act, and I see there were 2 instances of it where you looked at the Mental Health Act, Chapter 2802, where we now looked at, before we had just doctors in the public service, in the Ministry of Health. But now the doctors are in the Northwest Regional Health Authorities and in various health authorities, this will give us some level of comfort that we are not breaching any sort of laws that people could come and sue us after. So therefore, I looked at this, and I congratulate the government for this. I congratulate them also looking at, when I looked at, again, Section 61(1), where in the Mental Health Act, they expanded the category of persons who may be designated as mental health officers under the Act by including persons who are employed by the regional health authorities. So we needed this both for the doctors and for the mental health officers who are needed to go out and apprehend persons. But, Ms. AG, there's one request I may have to beg is there's a little deficiency where we have mental health officers under these, working under the regional health authorities. But some of them need what you call to do some sort of, they have to get some oath, they have to actually swear to some oath of allegiance. They have to actually have that. And if they do not do that, the newer ones may not be able to fully function. And if we are going to something called an apprehension order, where you need to go and apprehend somebody who's acting dangerously, a mentally ill patient, they sometimes have to depend on the few older ones who have taken this oath. So this is something I'm hoping that we can go further, where we can really make a dent on this. I look also, Mr. Vice President, at the fact that the issue of the dangerous drugs, clause 10. So clause 10 actually gives the authority the power of a constable who reasonably believes that a child is in the possession or using a dangerous drug or similar substance. Where now it broadens it, because before that, a constable may be able to act with just using tobacco and alcohol. And two things comes out of this. Two things stood out here, because we are now looking at protecting children more, and this is something I have to really thank the government. They have understood the need to open that act. Because, Mr. Vice President, I must say, right now in our nation, I am a bit scared. I'm a bit worried that, children and drugs, it's not just alcohol, it's not just the alcohol we are looking at, it's not just, we're looking at new drugs on the market, not just alcohol, marijuana. We're looking at new drugs on the market. And I would like, if you allow me to read into this, a concern I had where the Ministry of Education actually had a release where they, actually had that release telling the public new addictive drugs hit schools. And it was a drug called Molly, which is a new addictive drug, and it has hit the nation's schools, and the officials of the Ministry of Education are currently scrambling to get more. This is according to a report that was done in the newspaper by January 2019, an article from The Guardian, Rhonda Dowlatt. So the fact that the Ministry of Education realized that this Molly is in school, and Molly is like an ecstasy. And you see, so it's a different ballgame we are dealing with, Mr. Vice President, a different ballgame where you have now drugs on the market which are frightening, which can do great harm. You see, if I am a drug dealer and my market is selling marijuana, and suddenly now my market is dried up because everybody could plant their 3 or 4 plants, it means I am now looking for a new commodity. And this is the danger we are facing now. The new commodity is these mollies. The new commodities is this ecstasy. If they can get children hooked on this, they will have a market. And the frightening thing is, Mr. Vice President, is the frightening thing is, it's not just here that we have these drugs hitting us. These drugs, now put our children at risk. And these drugs actually, are finding their way in countries all over the world. And there was an article from the Telegraph where they looked at Chinese ecstasy drug linked to 125 deaths has arrived in Britain. And you see, this article by Charles Haynes, it was on the 2nd of June 2019, They were warning the population that if there's a Chinese drug factories which actually make this imitation drug and pushes it out on the market. So it's not just the coronavirus we have to worry from China. We have to worry about these drugs that are coming out, going all over the world, that the United Nations actually claim that they are banning these drugs. They're not allowed to bring in these drugs. So this bill recognizes the fact that it's not just alcohol, it's not just marijuana, but you have now to look at our children if they are acting hyper, if they are acting full of energy, if they somehow, those children are red eyes, they are actually on the go, movement, not sleeping. We have to be aware. And this is why this piece of legislation, actually, I felt so good that it's out there, because now it gives us the power to look at, look at other avenues where police constable could act. So therefore, what I might say, our children are at risk, but this recognizes it. But you see, when I looked at the legislation, one thing I was hoping we could add here, because in this clause 10, when we looked at section 3A of the Children's Act 4601, it said the constable shall warn the child, obtain the relevant contact information, and notify the children's authority of the incident. I am hoping somehow in that we could put and notify the Ministry of Education. For two reasons. The Ministry of Education will be able to look at that child. So if the incident happens outside, the Ministry of Education will have to look at that child, because that child could be in a school as someone who would be there selling the drugs to other children. So this will give that leverage now to the Ministry of Education to monitor that child too. Even if the child needs to get child support services to help in any sort of rehab, I think this is necessary in this piece of legislation, if it can be added. And when I looked at clause 11, where looking at the Shipping Act 5001, and we looked at section 406, and really speaking, what that did was increase the penalty from a fine of $100 to $150,000. So it actually updated the existing, the old legislation to be in terms of the new penalties that should exist. But most respectively, I'm hoping that, when I looked at the parent bill and I looked at section 394, they also had certain offenses and penalties there, Madam President. And 394 actually had some penalties, which I considered also all fees of $1,000 and 6 months imprisonment, in 394, 2 and 3, and most respectively, if the Attorney General could see, if we are now looking at fixing the fee structure in the bill, probably that may have been left out, and may need to look at. You see, the thing, Madam President, is if we are fixing the act, I think tie up all the economic ends one time so we wouldn't have to come back with this. I would like now to look at clause 12 of the bill, where it looked at the Plant Protection Act, chapter 63.56, where it actually, I think, widens the powers of the Minister of Agriculture in terms where he can now make an order exempting any article from classification as a restricted article, which requires a permit for importation under Section 3, provided that the article does not pose a phytosanitary risk. Now, all well and good, we may need to bring in stuff, we may need to stop any sort of any sort of jam system that occurs where you're bringing in stuff and you have to have the health inspectors go, the food inspectors go and inspect it. But you see, we have to appreciate the fact that if we do any sort of kind of less restriction on looking at these products coming in, we may run the risk of bringing in a plant disease. Because right now, in the United Kingdom, there's a disease called Xylella, where in the United Kingdom, they are very worried about this because this was an article, BBC News, Matt McGrath, 20th April 2020, Madam President, where this new infection, there's no treatment, just like the coronavirus. And also, the UK restricted certain trees coming in, imports coming in, and it could spread to a variety of plants. So even though, yes, I'm thinking we may want to ease up some restrictions to bring in certain stuff. The agricultural biosecurity is important, and the fact is we are already faced with a pandemic for humans. We have to be careful that we are now not opening the doors for any sort of diseases to come in. So I'm hoping that very careful checks and balances could still be entertained. And I think the Minister of Agriculture should know that, you know, with persons speaking about food shortages, his role is just as important as finance, just as important as health, and he has a very, very important role to play to ensure that plant viruses and pathogens do not enter our system. And as I was reading the Parent Act, Senator Ramirez, I realized there was also restriction on soil, but there's a chain down here that actually brings in potted soil. You may need to look into that, bags of potted soil, because there's a restriction in the Act, and we don't want anything to come here to disturb our agricultural economy. As I continue looking here, I want to just look at that aspect where concerning the Kariri.
Senator Dialson, you have 5 more minutes.
Sure. Thank you, Madam President. So Kariri, we saw that certain changes were made. IDC no longer exists. It was taken out. UNDP was also taken out. And what I found is that also, you know, other governments in the Caribbean region, they were left out. I got the impression they were left out. And I'm trying to figure out with Caribbean integration, regional support, I'm thinking somehow, you know, we may see if they are still, because the whole concept of Kariri was to have that integration within that Caribbean region for the development. So better, I think what we may have to do is make sure people don't think that we are just like Trump pulling out from WHO, President Trump pulling from WHO and these things. We have to ensure that we are still with our Caribbean neighbors, looking for better development post-COVID. Concerning the immunity given to the magistrates, I've heard a lot of concerns, and yes, we have to be concerned if, you know, we are in fact given immunity, because there are a lot of court cases before, Madam President, where it showed some deficiencies in the magistrates and some of their judgments that they give. So therefore, we should not take away the power from the little man to question. So once that normal citizen could still have judicial review on the magistrates, I would be satisfied with that, because I'm thinking we would really need to say, if we give too much power to the persons, the small man may think they now cannot challenge any sort of decision made here. And I would just like to mention the fact that when we looked at the Clause 7, Summary Offences Act, and we're looking at the increased penalty for cruelty to animals to $100,000. I find that's a bit excessive, but I don't know if that goes with international standards. But one thing I just wanted to mention is you have to understand, if somebody is cruel to animals, somehow we will have to see that when we have given them the $100,000 and to imprisonment for a term of 1 year, I am suggesting, Madam President, persons who are cruel to animals, they may be children who have what we call a conduct disorder, who could lead to something called sociopath or psychopath, we used to call it long term. So part of the imprisonment, persons who are there should also be added on to this piece of legislation with psychological intervention. So we would not be missing people in society who are cruel to animals because they have a personality disorder, which could go in the widespread community. So, Madam President, with that, I thank you for allowing me to take part in the discussion. And I'm hoping that I can hear from the Attorney General of some of my concerns. Thank you.
Senator Hussain.
Thank you very much, Madam President, for recognizing me and joining this debate on this Miscellaneous Provisions Bill 2020, which seeks to amend 18 pieces of legislation. And Madam President, while we may understand that we are facing a pandemic, we cannot, and I want to join with Senator Wade Mark, we cannot trample upon the parliamentary procedures in which are available to us simply to say that we can just amend 18 pieces of legislation in one go with a suppression of speaking time. And Madam President, it was right when speakers before me indicated that although we are amending 18 pieces of legislation, we have just about 3 of these pieces of legislation outlined in 3 clauses, which actually has some relevance to COVID-19 in terms of the extensions of deadlines for filing of certain documents, and also in terms of the extension of the limitation period in which certain matters are prescribed. And Madam President, if you would allow me to begin, I just want to look at Clause 4 and Clause 3 of the bill, which deals with the repeal of the Magistrate Protection Act and the insertion of a new clause in the Summary Courts Act. And you would remember, Madam President, we had quite a lively debate in this chamber when we dealt with the amendments to the Magistrate Protection Act. And if I may recall, there were many suggestions coming out from members of the independent bench and also the opposition bench, myself and then Senator Ramdeen, where we indicated that our position was to grant magistrates full protection simply because they are judicial creatures, notwithstanding the fact that they are creatures of statute and they are limited by the boundaries in which the powers are given to them by written law. And the purpose of that position that we took at that time, Madam President, was the fact that because they exercise a judicial function, we don't want magistrates to have hanging over their heads that they are under some level of pressure for personal and tortious liability. Because at that time, you would recall that the amendment came in as a response to one magistrate, I believe Mr. Jagru, who would have been sued personally, and then the matter was on appeal. So the government, I remember the Attorney General at the committee stage of the bill indicated that he required the Cabinet's approval to determine whether or not the government's position would be whether or not magistrates are going to be granted full immunity. Now, in this present amendment, as we see, it is read as, no action shall be brought against a magistrate for any act done by him in the execution of his office. Now, when someone is aggrieved by the decision of a magistrate, for example, in a preliminary inquiry, if a magistrate commits a person to stand trial at the assizes, having found that there has been a prima facie case made out against him or her, then available to the defendant, would be the avenue of judicial review, to review whether or not the magistrate would have exercised his discretion lawfully. And that comes from the fact that that decision can't be appealed because the magistrate is not sitting as a decision maker in that instance, but rather as an inquiring magistrate, just limited to the purpose of determining whether or not a prima facie case has been actually made out. Now, if a magistrate makes a final decision, for example, if he finds someone guilty of committing a criminal offense, then that person has the avenue of an appeal. When I look at this legislation and I recall the Attorney General's contribution in the other place, the Attorney General did in fact indicate that the right to an appeal and also the right to judicial review is available to the person who is aggrieved by the decision. And if that is the position of the government, then I can agree with this particular amendment. I know the Attorney General did in fact put it on the record in the event that there is some level of interpretation in the High Court, so that the pepper and heart rule can kick in to determine what really was the intent of the Parliament when passing this particular piece of legislation. So if we are preserving the right to have those avenues available, that of judicial review and appeal, then I see no difficulty with clause 3 and 4. Maybe, I don't know if the Attorney General, out of an abundance of caution, may want to expressly state that. Because at the end of the day, a magistrate can in fact err in the decision he makes, and a person must have those avenues available to him. Now, when we look at our present circumstances, this Senate has been engaged, especially in a lot of criminal justice reform measures. And one of those measures would be the abolition of preliminary inquiries. So once that kicks in properly, then that avenue will no longer be relevant, as now matters will be brought before the master, who will make the decision whether or not a sufficient case is made out against the accused person to stand trial in the assizes. And those are the points that I have regarding clause 3 and 4 dealing with the Magistrate Protection Act. Now, I'm looking at clause 6. Clause 6 deals with the Limitation of Certain Actions Act. And I could understand this particular, the rationale that this particular clause is being introduced in the Senate. And this is being introduced simply because we're speaking to Trinidad and Tobago. If someone has an action in tort or an action in contract, a person has 4 years in which they have to bring that action against the person, the tortfeasor, or the person who have committed the breach of contract from the date on which the cause of action arose. Now, because of COVID-2019, you would see, Madam President, that our court system has been limited in terms of the capacity in which hearings have been conducted. I myself participated in a virtual hearing, and I was quite impressed with the infrastructure in place by the judiciary, where I was in my office together with the litigant, and we had the comfort of having the judge sitting in his home and the other side at their office, and we completed an entire hearing on whether or not an injunction had to be discharged. And it was done smooth and efficiently. So the capacity of the court has been limited. I say that point to say that the capacity of the judiciary has been limited to only dealing with those matters deemed fit for hearing or matters that are considered urgent. Now, while the COVID-2019 pandemic affected us in Trinidad and Tobago, the civil registry was in fact closed for the filing of documents. And some persons at that stage, their limitation may have expired when the civil registry has been closed. Thereby, they would have missed the filing of their action in time to preserve it under the Limitation of Certain Actions Act. So I can see that we would have to give those persons that extension in which the limitation period has been now is enlarged, so that they can file their action quite properly without any preliminary points being taken before the matter proceeds in the High Court. And what I also agree with is the fact that that it's flexible, because this pandemic is very unpredictable. So that by order, the Attorney General can in fact prescribe longer periods in which the limitation period can extend, instead of coming back to the Parliament to determine whether or not we should extend it for a further period. Again, I would assume is contemplated because of the uncertainty of this pandemic, having regard to the fact that there is no vaccine having been developed as yet. So those are my comments with respect to clause 6 of the bill. Now, Madam President, I want to go on to what me and the Attorney General had probably public brawls on, which is the amendment to the Income Tax Act, because I have expressed strong views in the public domain, and so has the Attorney General, with respect to these amendments. And it has been my position, Madam President, that Section 4 of the Income Tax Act was in fact inserted, and it's a universal provision, I dare say, because most of the democratic jurisdictions and countries in the world has that level of protection for taxpayers' information. And Trinidad and Tobago also falls within that category. Now, Madam President, you would also recall that we had to amend the Income Tax Act in the Income Tax Act 2018. And there were certain exceptions being created for the availability or the disclosure of taxpayers' information. And if you would permit me, Madam President, to just reflect on the 2018 amendment, because they're directly relevant to these matters before this Honorable Senate now. Because in the 2018 amendment, which is very similar to what we're doing now, I would look at clause 14(4) capital A-C, which deals with the provision of a witness statement to a police officer of the rank of superintendent or above for the purposes of any criminal investigation or criminal proceedings where the witness statement relates to information disclosed under compulsion of law, under the Act or any written law, and it must also be accompanied by the consent of the Director of Public Prosecutions. Now, my issue with this is quite simply this. It is, Madam President, that under the 2018 amendment, it was prescribed that there were certain pieces of legislation that the police can make an application under by the court to attain or to get taxpayers' information. And those pieces of legislation would have been if a person commits an offense under the Proceeds of Crime Act, under the Anti-Terrorism Act, under the Prevention of Corruption Act, and offenses involving fraud or dishonesty. And once these offenses fall within those categories and the taxpayer information is relevant, then the police officer can make an application to the court ex parte, which means without notice, and the court can direct the Board of Inland Revenue in order to disclose the taxpayer's information. Now, Madam President, we are seeing here in this present piece of legislation that notwithstanding, I know the Attorney General will argue the fact that there is some level of protection in the form of the constitutional protected body of the Director of Public Prosecutions having to consent prior to getting the taxpayer's information. When we look at the 2018 amendment, I was comforted by the fact that there was some level of due process in the form of a judicial officer, which is the court. Now, in this present framework, the court is absent. There's no due process in terms of how the police gets the information. It's simply that once he requires a witness statement and maybe an offense is being investigated, it doesn't say whether or not a charge was in fact laid or an indictment was preferred. All it deals with is for the purposes of the investigation. Or I'm sorry, Madam President, so it's also for criminal proceedings. In those events, then the police officer simply goes to the BIR and they can get the information, and it must be produced in the form of a witness statement. Now, Madam President, there are certain issues I can ask the Attorney General to look at because I want to close this particular piece of legislation with some level of constitutionality. Now, I want to ask the Attorney General to contemplate an instance whereby the police officer goes to the Board of Inland Revenue and an officer refuses to give the information. What will be the position of the police in those instances, whether or not they would be able to get the information? Secondly, available to the Director of Public Prosecutions in any criminal proceedings would be the power of the Director of Public Prosecutions or even the court of its own volition to call the witness or even call for certain documents, thereby producing the documents in court under sworn testimony for the fact that they can in fact be, if they give false testimony in those cases, then they will
face the offense of perjury. Now, Madam President, in this instance, the evidence in which the persons will be given will be in a witness statement that is unsworn. What does that mean? It means that, in fact, if someone fabricates the evidence, he, in fact, it's only at the stage when he reaches the court and he gets into the witness box, then he swears unto the evidence that he gave is, in fact, truthful. So those are the issues that I looked at with respect to this particular clause. In terms of the power being given here, I believe it's very wide, and we are offering a lot of protection to the officer who, in fact, gives the information to the police. Now, there's also the issue here of Clause 4A, sub A, which deals with information which, at the time of disclosure, is or has already been made available to the public from other sources. Now, Madam President, this troubled me, because in what instances will a taxpayer information be made public from other sources? And what does the term other sources mean? What if a person's taxpayer's information has in fact been released illegally or unlawfully? Does this close this with some level of protection? Because in that event, it would have been released from other source, and also it would have been made public. So I don't understand what is the rationale for that particular subclause. Secondly,
Senator Hussain, you have 4 more minutes.
Already? Okay. With respect to clause B, it deals with collecting a summary of information, but to protect the identity of the taxpayer. Again, who is this information being given to, and who is the proper applicant to make an application to get this information? So these are the questions I'm asking the Attorney General, if he can give us some level of details in terms of how what is the rationale for these and how it's going to work. Who are the proper bodies or the proper applicants who are going to get this particular piece of information? Because in the Senate, Madam President, we had expressed strong views with respect to the independence of the Trinidad and Tobago Revenue Authority, which in fact was passed, and we did express strong views that there may be some level of interference with the independence of the authority. And now seeing these particular pieces of amendments coming to further water down the secrecy provisions of the income tax legislation, it gives us some level of worry, Madam President, that the information may not be protected sufficiently. And with these kind words, Madam President, I thank you very much.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President, for the opportunity to contribute on this Miscellaneous Amendment Bill 2020, which, Madam President, as we know, seeks to amend 17 pieces of legislation and repeal the Magistrates Protection Act, Chapter 603. Madam President, I would direct my attention to 2 clauses in the bill, clauses 7 and 12. In relation to clause 7, Madam President, that's a clause that proposes to change the current provisions in the Summary Offences Act relating to animal cruelty. Madam President, the Summary Offences Act would be 100 years old next year. And a lot of us have suffered through the provisions of that piece of legislation, which is very important. Some of the provisions are woefully outdated, but many of the provisions are still in use and still very active in relation to a number of matters that are before the Magistrates Court. The provisions in relation to cruelty to animals is to be found in the Summary Offences Act at Section 77 in relation to confinement, 78 to 84 in relation to cruelty, 85 to 89 in relation to detention. But Madam President, the key area is this area of cruelty. Madam President, In relation to cruelty, the only amendment to the 1921 legislation was made 67 years ago. So what we have in relation to cruelty is now 67 years old. But the government didn't just sit back. This issue of treatment of animals and animal welfare has been very topical across the country for a long time. And I must say, prior to my appointment as minister, there was in train a project to amend the legislation dealing with animal diseases and importation. Now, I must say, Madam President, that in my portfolio as Minister of Agriculture, I essentially deal with what we call commercial animals, animals that are raised for consumption or animals that work. And I do not directly have responsibility for domestic animals, but the veterinary profession also happens to form part of the portfolio. We have a lot of vets in the ministry, and we do in fact get involved in domestic animals from time to time. And in modernizing, prior to my appointment, ICA was engaged as a consultant to assist the ministry to modernize that animal diseases importation legislation. And that legislation essentially sets out the phytosanitary standards in relation to the importation of meat products and animals into the country. I inherited that work, and with the support of the Honorable Attorney General and his team, we were able to come up with different versions of the modernization of that and eventually settled on a version that was laid in this House in September 2019. And that piece of legislation, Madam President, I don't want to go into it except to say that is the first attempt really to develop animal welfare standards relating to domestic animals in the country as well as working animals. And that was laid in this House, and my colleague, the Honorable Attorney General, has given the assurance that we would give it priority and have it debated. So that, to my mind, was the first significant step. I must say also, Madam President, there is a private security industry bill that is in the House that was subject to the work of a joint select committee of Parliament. And in that work of the joint select committee, we were also very careful because, Madam President, a lot of people don't recognize that we have working animals in this country. For example, the dogs that are used in the security industry are categorized around the world as working animals. The dogs that are used in the police service are working animals, and the dogs that are used in commercial farming are working animals, and they have rights too. And it's not something that we have looked at in the way it should have been looked at, but we've done that in that bill that is laid in this House. But in that private security industry bill, we ensured in relation to all the provisions relating to security companies that we put in there adequate language that forces those companies to adopt certain standards in relation to training persons in the handling of working animals, and also the care, the comfort, the health and safety arrangements of those animals, even the working hours, as though they were a human being. Madam President, having laid the bill in September 2019, we also, through Cabinet, a committee was appointed because this bill anticipates the creation of animal welfare standards. And in September 25, 2019, I appointed a 17-member committee to develop those standards in anticipation of the passage of the legislation. And that committee, Madam President, worked very quickly and very hard. The committee was chaired by Dr. Victoria Lashley from our ministry and had as its members Professor Marlon Knights from University of Trinidad and Tobago, a livestock expert who has worked here and abroad, Ms. Natasha Hussein Bakshaw, our legal director in the ministry, Kern Johnson from the THA, Ms. Solange Souza from the AG's office, Nirmal Bipta from the Zoological Society of Trinidad and Tobago, my predecessor, Dr. Riza Mohammed, who has lent tremendous support on wildlife conservation and also animal welfare to me as Minister, Madam President, Monique Kelman, a vet student at the University of the West Indies, Shanaz Mohammed, I believe, Madam President, was the first time a secondary school student in this country was appointed to a cabinet-appointed committee, and she brought the views of the young people in this country. Nalini Dial, activist from Animals Are Human Too, Joel D'Souza from Give Our Animals Love, Sita Kuruvilla from the TTSPA, Krishandat Baliram from Animal Rescue Association, Mr. Darren Carmichael from the Private Security Company Industry, Sarah Maynard from the Animal Welfare Network, Catherine Cleghorn from Animals Alive. There were other persons who were co-opted to work on the committee, Madam President, and that committee, on the deadline, January 3rd, 2020, I thought they would have been so lost in Christmas and New Year celebrations that they may not have made the deadline. Madam President, on the deadline, January 3rd, 2020, they presented me with a 93-page comprehensive report on animal welfare standards in this country. Madam President, while we await the debate on that bill that has been laid and the development of these standards, what we've discovered is that animal cruelty still continues in the country. And the Attorney General, Honorable Attorney General, looked at the law again and felt that an immediate fix would be to amend the existing provisions in the Summary Offences Act, to which I referred to earlier. So what Clause 7 proposes to do, Madam President, is to amend the key sections relating to animal cruelty in the Summary Offences Act, amend Section 79(1), Section 30, and Section 83(1). And the current provision in relation to the offenses of animal cruelty carries a fine of $400 or the risk of imprisonment for 2 months. And this Clause 7 of this bill proposes that we increase the fine from $400 to $100,000 and the term of imprisonment from 2 months to 1 year. And this is just the measure that we put in place now, subject to the debate on the bill that is laid in this House, the Animal Diseases and Importation Amendment Bill. And I understand that my colleagues have no problem in supporting this bill, inclusive of Clause 7. The other provision, Madam President, is this provision in Clause 12. And I thank Senator Dial Singh for his treatment of the clause and the concerns he has raised. Madam President, the Plant Protection Act is 1975 legislation. 45 years ago, it came into our law in this country. And Section 3 of that legislation requires that an import permit be obtained for a broad range of products which are categorized as agricultural products. As Senator Dial Singh correctly pointed out, it includes soil, it includes plants, it includes peas, beans, a wide range of agricultural products. But Madam President, it also covers things that are so far processed that they ought not to be considered as something that is likely to create a pest risk in Trinidad. For example, Madam President, let's take peanut butter, for example. Peanut butter is so far processed that there is zero risk of a jar of peanut butter introducing pests into the country. But the mere use of the term peanut makes it an agriculture product. And for that reason, import permits are required. And I could go through the list. Madam President, would you believe that because alcohol has an agriculture base, whether it is beet, whether it is potatoes, whether it is cane, it falls in a regime where it is classified as agriculture products. In fact, that is why, Madam President, $500 million in alcohol finds its way into the food import bill that we talk so much about. Madam President, Since 1975, there has been developed something called the International Standards for Phytosanitary Measures, ISPM 52. And what that does, that is an international standard which allows local authorities, what we call national plant protection organizations. In other words, the person in the country overseeing the importation of agricultural products, it allows those persons to determine whether an import permit should be required or should not be required. And ISPN PM 52 sets out in great detail. I'll send a copy to my colleague, Senator Dial Singh, because he seems very excited about this topic. It sets out in detail how we determine whether an import permit is required. And the criteria is based on the level to which the item has been processed and whether or not the item is something that is going to be planted and used for planted material. For example, seeds. Seeds can introduce pests into the country, and plants can introduce pests into the country. Logs with bark on, for example, could introduce pests into the country. That is why we've long insisted that logs coming into Trinidad and Tobago have their barks removed. So those are things that are obvious. But when we get into the processed items, the ISPN 52 believes that there should be no import permit requirement for those things. And for example, I said peanut butter, Madam President, things that have been fermented like yogurt, pasteurized like milk, roasted like coffee beans, preserved like jams and jellies. Madam President, you'll be surprised that even in your some of your everyday products, like your red cherries, which you use in your baking. I know you enjoy baking, Madam President. Your red cherries, your cucumber that is preserved, your chow chow that is imported, all those things with carrots and cucumber and onions that has lost their ability to introduce pests. We have to have import permits. But Madam President, it's not just the import permits. When I came in as minister, 100% of containers landing into this country had to have a plant quarantine officer present. I met an overtime bill of $4 million, and it was something that was out of control. And my colleague, the Honorable Minister of Finance, through the Central Audit Committee of that ministry, conducted an audit and gave me some startling figures and some practices which were intolerable. I set about to reduce the workload and reduce the involvement of plant quarantine and to focus them on the risks and the risky areas and the work that has to be done. This, Madam President,
Minister, you have 5 more minutes.
This, Madam President, will significantly reduce that work by about 75%, and it will reduce the cost and the overtime and the headache that importers go through. For example, during this COVID period, on a daily basis, I've had to respond to calls from importers who have dal, chana, peas, red bean on the port, rice on the port, and they're unable to locate a plant quarantine officer to be present. And to answer the question from my colleague, Senator Dial Singh, about introducing risks, I will tell you that what this bill proposes that the minister may by order, Section 3, the existing Section 3 of the Plant Protection Act is broad. So it leaves the minister or the ministry with no discretion. Import permits are required. What it does is that it allows the minister by order to publish a list of commodities relating to agriculture, which because of their processing or for other reasons based on international criteria, should no longer require an import permit. And the minister will do that based on the advice of the research people, the National Plant Protection Organization, and the other things that are used to determine the extent of processing and the likelihood of risk. And I believe, Madam President, this is an important measure. Importers will still have to comply with the Ministry of Health requirement in relation to food quality, food integrity, and other matters that are public health matters. But in relation to our job in the ministry, which is essentially the introduction of pests and pest risks, I believe that the minister, whoever that person is, will act in accordance with advice and will issue the orders which are appropriate, and will also make the system of imports efficient, effective, and reduce the strain on the people who assist in feeding this country. I thank you very much, Madam President.
Honourable Senators, the sitting will now be suspended and we will return at 1:35 p.m.